Okay, Mike Benoit here again. This is more on my situation where the IRS stole my home. And this part of the scenario is where I applied I submitted a motion for reconsideration of the judgment. And it's called a Rule 59 motion. A reconsideration of the Rule 59 motion for summary judgment. And I lay out the introduction to speak towards, actually showing a new situation that has arisen where the IRS is creating stuff out of thin air, bogus notices of assessments, if you will, or notices of deficiencies, whatnot. And I'm not going to get into the details on that. That's like a little YouTube video on its own. But that's the introduction to my motion for reconsideration. Now, of course, the grounds for reconsideration, Rule 59, preserves the district court's right to alter or amend the judgment after the judgment is entered. Motions to alter or amend the judgment are appropriate when they involve reconsideration of matters encompassed in the decisions on the merits. Okay. 4 grounds that justify altering or amending a judgment. And what those 4 grounds aren't jumping at me right now, so we'll just skip that. We'll go to my argument. So I submitted a bunch of new evidence that demonstrated how the IRS just creates this stuff out of thin air. And so even though this is a new it's a new situation that had nothing to do with the previous situation. It just shows the inclination of the IRS. Now, so that was my argument to say, hey, just maybe they did the same kind of thing on my original case here and don't believe what they told you as gospel. So it just demonstrates that that they're arbitrary, capricious, and fraudulent treatment in general. Now, to the meat or crux of the matter here, the court's order that said, hey, you lose summary judgment, IRS can sell your house, etc., etc. The first clear legal error occurs on line 1 under the caption. Again, legal error is one of the grounds for reversing the decision. Under the caption background, the court, this is the statement the court made, the court finds the following facts to be undisputed. And then, of course, it has its footnote, and in their footnote it talks about that my disagreement on the facts is just really a disagreement in the interpretation of the law, not a disagreement in the facts. So they have to, for summary judgment, declare that the facts are not in dispute. Otherwise, they don't get a summary judgment. What happens if there's no summary judgment? Well, then I get trial by jury. Kind of a nice, wonderful thing that was supposed to be guaranteed to us by the Constitution. All right, so we go there. And then another false statement in the background section of the court's decision is that during 1995 and 96, Benoit operated a flyer delivery service. Well, see, that's a piece of information. Now, where would the judge get that? Well, he got that from the government's motion for summary judgment. It's a statement in the government's motion for summary judgment. No, the only evidence that goes towards that issue is my deposition. And my deposition says basically that I think the business started in 97. So the evidence for this is that 95 and 96 I didn't have a flyer delivery service, but the government says that, so the court quotes that in their decision. Now, defendant did not receive compensation from a flyer delivery service in 95 or 96. Yet the court said that in its background. All right. And I actually put in my motion for reconsideration the testimony that I made in that regard. And then one of the questions was it active in 1996? I said something like, I think so. I don't know if it started in 96 or 97, right? I'm not sure. So there is no evidence that I got income from a flyer service in 95, 96, yet it's in the court's background information in their decision to grant summary judgment for the government. Now the court further lists in the background section of its order a list of irrelevant one-sided facts. That I had 10,000 shares of stock in the company, and that I did not file tax returns for 95 and 96, and that I didn't pay taxes in decades, and that was a misstatement of what I said, and that's not what I said. There was no mention of the following facts, and then I gave them. There's a whole list of facts on my side of this issue. Now the court also stated in the background section on its order of December 21st. This is a big one right here. They state that, and this is in background section of their decision, that the date upon which the government filed the instant motion, that's the motion for summary judgment, Benoit owed the United States $144,847.44. That is a statement put in the background section of the court's decision to rule against me. They took that as a background fact of accuracy, of being the truth. Put it in the background section. So they start off with, hey, Benoit owes us money. Presumption that you owe the money. So if you look at the decision, there's no attention paid to my facts. In the background again, the court makes this statement: Benoit disputes many of these facts. However, the court finds that Benoit's disputes, unless otherwise noted, involve the legal significance of the fact rather than a dispute about the fact. Accordingly, the court finds that the facts themselves are not disputed. Now, facts like I didn't have any income, and the court didn't prove I had any income. The judicial department of the IRS did not prove that I had any income. So that's a fact. And of course, we'll get into their motion 4340 or their form 4340 in a second. But next thing, summary judgment. All right. The burden of proof in this, in all cases, is on the plaintiff, not the defendant. So I reiterate the fact that the government never produced assessments, and that the moving party, and that'd be the government, on an issue, whether a claim for relief or affirmative defense party, must establish beyond peradventure all of the essential elements of the claim or defense to warrant judgment. And it's not incumbent for me to prove that I don't owe any taxes. The Internal Revenue Code, then we go on down. The court states that summary judgment is proper when there's no genuine issue. And of course, if there's no genuine issue, yeah, summary judgment would be proper. But there's a ton of issues here, and then for the court just to declare there's no issue, there's no genuine issue, is to remove your right of trial by jury. These summary judgments are an abomination because, you know, if whenever summary judgment is granted in favor of one party, when the other party is insisting that there's facts in dispute, and you know, they would take a trier of fact, is this a fact or is this not a fact, whether or not someone had taxable income is a fact. And just to say they did doesn't make it a fact. And to say you don't doesn't make it a fact too. But the burden of proof is not on the guy to say, well, I didn't have taxable income. Now I got to go prove I didn't have taxable income? No, burden of proof is on the government to prove that you did have taxable income. The Internal Revenue Code provides for a specific procedure for assessment, and that's under 6203. It's an administrative determination of a tax liability, and until the assessment is made, the tax has not been found owing. And that's why I was insisting for copies of the tax assessment, which I never got. Did the court examine the evidence in the light most favorable to the non-moving party? Well, I think if you look at this case, I'm the non-moving party. They didn't. They, of course, looked at the evidence in the most favorable light to the moving party, the government. Now, we may find that strange that the government would be on the side of the government, but that's what happened. Now, under the court's decision, under discussion, they give a legal standard in an action to collect taxes. They go to say that the burden is justified by the production of deficiency determinations and assessments for unpaid taxes. Okay, deficiency determinations and assessments. Assessments were never produced in this case. The major problem here is that no production of assessments were made in this case. I contested the deficiency determinations at the onset, and at the same time demanded assessments, unless powerless to show that the determinations were arbitrary, excessive, and without foundation when no assessments were ever produced. Frankly, at the very minimum, defendants should be entitled to actual copies of assessments prior to summary judgment being made. You know, if they say, here's the assessments, at least, you know, somebody's officially, there's a form that says, hey, here they are, the assessments. They're done, you know, contemporaneously. At the time the alleged assessments were made, a copy of those assessments. Now, the court claims, based on Hughes versus United States, that the simple production of certificate of assessments and payments is sufficient for summary judgment, which is not the case. That's not what the Hughes court said. The Hughes court said Forms 4340 are highly probative, and in the absence of contrary evidence, it's sufficient to establish that an assessment was properly made and that notices and demand for payment were sent. But the court is trying to say that Huff stood for the proposition, my court, or my judge, is trying to say that Huff stood for the proposition that the production of certificate of assessments is payment. The production of certificates of assessment and payments is sufficient for summary judgment. That's not. That's not what Huff said. They're highly probative, and if there's no other evidence, then they're sufficient. But that's if there's no countermanding evidence. In my opposition papers, I produced contrary evidence which rebutted the presumption of correctness of the certificate, and by extension, the alleged assessments. I almost want to read this like this. That'll work. Then with my opposition to the plaintiff's motion for summary judgment, I agreed with the Hughes court, and I demonstrated by contrary evidence that assessment was not properly made in the case, and that the Forms 4340 do have defects, and that the two sets for 95 and 96 are not the same. They're materially different. The first set issued in 2006, and pay attention to that. These forms 4340 notices of assessments. I better call them the right thing. I'm going to miscall them something here. They're certificates of assessments. All right, they're not actual assessments. I showed that there was two forms that were issued, one set in 2006, one set in 2007. Now the set in 2006 shows an original assessment for 95 of 14,857 and 96 50,017, totaling a 64,874.50. The set that was dated in 2009 shows original assessments. Again, original assessments here, 16,811 compared to the 14,857 before, and then 57,000 compared to the 50,000 in the other set. So they're not the same. So you've got two sets here that are materially different. So that would take the presumption of correctness. One of them's correct, or they both can't be correct. And which one's correct, or are neither of them correct? So, and then in the Huff case, where it said that the court found that this condition was one of a genuine issue of fact, that I hadn't received any copies of these assessments. So that, according to Section 6203, so there's actually a genuine issue of fact on that circumstance, declared by the Ninth Circuit Court of Appeals, which is a higher case than this, and the court should rely on it and not countermand it. So under the Huff, the defect in Form 4340 and the fact that the record contains no evidence indicating that the Huffs received copies of their assessment pursuant to their request, we conclude they're genuine issues for trial. All right. So I satisfied that requirement stated in Huff above. It didn't matter to this particular judge in this court. I also showed that the form that was listed on the Form 4340, the item that said substitute for return, it says that substitute for returns were made, yet I proved that the government didn't have these. That I've got a letter saying they didn't have them. That would be enough to rebut the presumption of correction this form was given. So again, I'm not trying to win outright here on this opposition to the summary judgment. I'm fighting to get my jury trial. So, and to show that, hey, there's enough for this to go to a jury trial. Then the court stated incorrectly, because Benoit fails to identify any facts to rebut the legitimacy of the Form 4340, the only permissible inference is that 95 and 96 assessments of his tax liability are valid as a matter of law. That's kind of bizarre, because I also go in my opposition papers to show why these deficiency or these penalty sections also didn't apply to me. So any facts to rebut the legitimacy of the Form 4340, well, there were two of them that were in contradiction of one another. There were statements on the form that a substitute for return was made, yet the government doesn't have any. And the penalty section, I showed down how those penalty sections did not apply to me. So with the court saying I'm not producing any evidence, that's interesting. Actually, it's really interesting when I get to it further on, when we find out, well, we've already found out that the government's evidence was not submitted under a proper declaration or affidavit stating that they had firsthand knowledge. It was stated under information and belief, which is a level that is not sufficient for a summary judgment process. The person who submits any evidence can't do it under information and belief. That really equates to hearsay, if you will. So that's another factor that should have thrown the summary judgment out the window. So the court claims that the government submitted sufficient evidence to show that this income was earned and taxable. That's just an absolutely incredible statement, because there's no evidence that I had any income. The only evidence they had that, or how much, there was no evidence there was any income. So they just say my objections to the government evidence is without merit. Now, who would be surprised about whether or not the government's going to rule in favor of the government? And I know if anybody actually watches this and gets this far into it, you know, it's kind of mind-boggling and spinning a little bit. But keep in mind that we're talking about jury. We're just, if a jury hangs me, hey, you know, I agreed to live under this political division called the United States of America, and there's a tacit agreement because I was born into it. So I agree to the rules and the process, due process. And that due process is a trial by jury. To circumvent constitutional protections under the guise of some other judicial aberration of summary judgment, and where the person that judges or rules on the summary judgment is the government, and ruling in favor of the government, and declaring a statement that there are no facts in dispute, when any attorney or lay person looking at all of this would say, well, sure looks like there's facts in dispute to me. Gives me that opportunity to get in front of the jury. The other, by denying that opportunity, what can the government do? They can say, they can take a $10,000 thing and turn it into a $200,000 thing and take your home in the process. And if you can't go in there and, well, prove a negative, then they're going to deny you your trial by jury. The court states, pursuant to 26 U.S.C. 7403, that it may order the sale of the Benoit family homes. Without, I'd like to know how that's even possible without constitutional guarantee by trial. The idea that I presented no evidence to prevent the government from foreclosing on this lien is just nuts, wacko. So, finally, the court does not address any of the points of my summary judgment. Doesn't deal with the government of the state of California's lien. Makes no adjudication on the validity of that lien whatsoever. Just they're in the queue to get proceeds off the forced sale of my house without any validation of the lien, and that's required under the code. And that's that for this motion for reconsideration, and you can guess how that came out. Thank you very much. See you in the next one.